This is the Child Protection Court of South Texas. Time is 9:35 a.m. The parties and all those observing are admonished these proceedings are official and being recorded by the court. Parties are also admonished to adhere to the decorum of court and your behavior, your appearance as if you were sitting in an actual courtroom, and not to record these proceedings. Mr. McKeska, would you please begin the announcements? And if each attorney would please prompt their client to announce.
Yeah, Drake McKeska, attorney for the department. Ms. Rios.
Good morning, Kimberly Rios, CPS caseworker.
Good morning, Carol Maketa, family-based supervisor.
Donna Swallow, attorney ad litem for Ben Levinson, the father. Ben, could you unmute and state your name, please?
First, the attorney ad litem for the respondent mother, Kara Levinson. Ms. Levinson, can you announce, please?
I'm Kara Levinson. I'm the very proud mom of Max and Ollie.
Lucinda Canavan Mance, attorney ad litem for the children. I'm ready.
Leah Peterson, Hill Country CASA case supervisor.
Jeannie McDaniel, Hill Country CASA guardian ad litem for the children.
Mr. Levinson, are you having a problem keeping your video on?
Yes, Your Honor.
All right. Well, as soon as you can get it back up, please. And Ms. Levinson, I need you to keep your device still, please. All right. Anyone who's not an attorney or will be giving testimony, please raise your right hand. That includes both of the parents. Do each of you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Yes.
All right. Okay. Mr. McKeska, how is the state going to proceed today?
Yes, Judge. So we went to a pre-262 mediation last week. I believe it was on Friday. And we were able to reach an agreement with the father. And then this morning, Ms. Acosta and I were able to talk and finalize an agreement with the mother. So we are prepared to move forward with the agreements that were reached.
Okay. So do you have an MSA or a Rule 11 on the father? Yes,
Judge.
And then you have an oral agreement with the mother?
Correct, Judge.
Okay. Let's hear the MSA first, please.
Yes, sir. So the agreement that we reached on February 3rd with Mr. Levinson is as follows. Number one, we agreed the Rule 11 is binding on all parties who signed it, and it was irrevocable. Number two, the agreement to name the department as the temporary managing conservator of the children and the father as the temporary possessory conservator. Number three, the department agreed to stipulate to section 262.013 of the Texas Family Code that by reaching an agreement for temporary orders, it was not an admission to the allegation contained in the affidavit. Number four is moot at this point because we reached an agreement with the mother. However, just for sake of the record, we agreed that if we did not reach an agreement with the mother, the department would not present any evidence regarding the father that occurred prior to January 10th, 2023, including but not limited to exhibits provided in the department's response to disclosures under 262.014 of the Texas Family Code. Number five, the department agrees to do an expedited ICPC home study on the paternal grandmother in New Mexico. And we did double check the ICPC regulations, and we are able to conduct an expedited home study under the regulations. Number six, all parties agree to waive aggravated or seeking aggravated circumstances in this case. Number seven, we agreed that respondent father will have visitation supervised by the department for at least 1 hour weekly. At a minimum, once his bond conditions are modified and he's allowed to have contact with the children. Number eight, father agrees to go to inpatient treatment as soon as possible and engage in aftercare services. He also agreed to complete a psychological evaluation and follow recommendations, engage in individual counseling, and complete a parenting program. And then number nine, the parties agreed to use electronic signatures as if it were their original signature, and that it would have the same legal and binding effect. And then it was signed by all parties and the mediator. With regard to the agreement with the mother, a lot of the provisions are the same. with a few differences. So number one, parties agreed to name the department as temporary managing conservator of the children, and the mother as temporary possessory conservator. The same stipulation to section 262.013 of the Texas Family Code. The included agreement to do the expedited home study, ICPC home study on the paternal grandmother in New Mexico. Agreed to waive the seeking of aggravated circumstances. With regard to mother's visitation, we agreed that in the event that the mother travels to the DFW area where the children are currently placed, she shall have 1 hour weekly visits supervised by the department. In the weeks that she does not have in-person visits, we agreed that she would have virtual visits with the children for up to 30 minutes. And then if the children are within 100 miles of their home of origin, the mother shall have supervised visitation with the children in person weekly for an hour, which can be increased by agreement of the parties. With regard to services, the mother agreed to complete an OSAR evaluation and follow recommendations, complete a psychological evaluation and follow recommendations, attend individual counseling, and complete a parenting program.
The only thing I didn't get was if the virtual visits are 30 minutes, what's the frequency?
It would be weekly, Judge. It would be once a week. Sorry.
That's okay.
I thought, may I say something?
Not yet, Ms. Levinson. Hang on. Is that the entire agreement as you understand it, Mr. McKeska?
It is, Judge.
All right. Ms. Acosta, is that your understanding of the agreement? Sounds like Ms. Levinson has a question.
There was one thing with.
Ms. Levinson, I need you to keep your seat while we're in the hearing, please.
Okay, I'm sorry.
Go ahead, Ms. Acosta.
If for some reason mom isn't able to travel to the Dallas-Fort Worth area, then the visits were going to be 2 hours, once per month in person.
Mr. McKeska?
That's fine, Judge.
Okay, give me that one more time so I make sure I get it right.
So, sorry, go ahead, Mr. Acosta.
If Ms. Levinson is unable to travel to the Dallas-Fort Worth area to visit with the children, then her visits are going to be once a month for 2 hours. And all visits are able to be increased by agreement of the parties.
Ms. Levinson, is that what you were going to ask about?
I was under the understanding that they were supposed to be like once a week.
Mr. McKeska, that's not your understanding, correct?
The visits, all visits are considered once per week, with the exception of the change that Ms. Acosta made. That was part of the original agreement. I thought we were substituting it out, but it's fine. It's inconsequential.
Okay.
All visits were weekly, so either in-person visits, the virtual visits, or the 2 hour visits in the DFW area.
And at any rate, she's getting weekly contact with the children.
Yes, Judge.
It's different based on geography and her ability to travel.
Correct.
All right, that's my understanding too. Okay. All right, Ms. Acosta, that's your understanding of the agreement?
Yes, and just really quick, was it in there that if the children are within 100 placed within 100 miles of their, okay, then the visits are weekly?
Right, supervised for an hour.
Yes, that's my understanding, Judge.
Ms. Swallow?
Yes, Judge.
Ms. Mance?
Yes, Judge, thank you.
Casa?
Yes, Judge, thank you.
All right, Ms. Levinson, you've heard the agreement and you've heard the specific issues that we've just spoken about. Is that your understanding of the agreement you made?
Sure.
Is it or not?
I've only talked to my attorney like twice. So yeah, it's kind of all news to me.
But that's the agreement that you made, correct?
Like 15 minutes ago? Yeah.
It is the agreement that you made, and you had a chance to discuss it with Ms. Acosta.
Yes.
All right. Were you forced to enter into that agreement?
I mean, I don't feel like I had a leg to stand on.
That's not what I'm asking you. I need you to keep your seat, ma'am.
Oh, I'm trying to turn the light on. Okay, it's fine.
Hang on. Let me ask you this question again. I want to make sure you understand it. Did anybody force you to agree to it? I didn't ask you if you had a leg to stand on. I asked you if somebody forced you to agree to it.
No one forced
All right.
me.
Did anybody make any promises or inducements to get you to agree to it?
No.
So this is your voluntary agreement.
Yes, Your Honor.
Are you asking the court to approve it today?
Yes, Your Honor.
All right. Mr. Levinson, same questions for you. Is this your understanding of the agreement? Mr. Levinson, you just need to unmute, sir.
I think this works, Your Honor. Can you hear me?
I can hear you now. Is that your understanding of the agreement?
It is.
Did you have a chance to discuss it with Ms. Swallow?
Yes, sir.
Do you understand it?
I do.
Were you forced to enter into that agreement?
No, Your Honor.
Were you made any promises or inducements to get you to agree to it?
No, sir.
Are you asking the court to approve it today?
I am.
I'm not sure if I said it when we were here last, but the court will find that the parents have entered appearances in this case by virtue of their participation in the mediation, this hearing, and their agreement. Department is relieved of any obligation to serve the parents if they have not yet been served. Court will find there's sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the children caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the child. Court finds the urgent need for protection required the immediate removal of the children and reasonable efforts consistent with the circumstances providing for the safety of the children were made to eliminate or prevent the child's removal, and reasonable efforts have been made to enable the child is returned home. Court takes judicial notice of the affidavit filed in this suit as it pertains to reasonable efforts. Court will also approve the agreement of the parties and the stipulation pursuant to Chapter 262.013 that the agreement of the parties in this matter does not constitute an admission of the allegations in this case. Court will name the Department of Family Protective Services as the temporary managing conservator of the children. Court names both parents to be temporary possessory conservators of the children. Court will approve all aspects of the agreement stated here on the record today. And the court will order the expedited home study on the paternal grandmother. What is her name? Court will expedite the home study, ICPC home study on a Nevinson. Court will approve the agreement of the parties to waive any pursuant of aggravated circumstances in this case. Court approves all the conditions of the visitation as stated by Mr. McKeska. Parties on the record, and court will order a family group conference for the parties to develop family plans of service that are narrowly tailored to address the concerns that brought the children into the care of the department. And the court will order the services that the parents have agreed to as stated on the record by Mr. McKeska. Your next hearing is going to be a status hearing, February the 22nd, 2023 at 10:30. It's February 22nd, 2023 at 10:30. Do you need me to repeat any of the order of visitation? I mean, I wrote down verbatim what you said.
I don't believe so, Judge. We'll include it all in the order, and we'll make sure that all the language is correct. I'm sure Mr. Acosta will correct any mistakes I make.
All right. And that'll be the order of the court. I do want to hold indigency hearings briefly. Start with you, Mr. Levinson. Mr. Levinson, are you currently employed?
No, Your Honor.
All right.
Yeah, let me say yes, but I don't think there's any income from it.
Okay, so you're employed, but you're not receiving any income.
From that employment, no.
You have income or resources from any other source.
Yes, sir.
What source is that?
Real estate, liquid assets, and some investments.
All right, and approximately how much liquid assets do you have right now?
Yeah, I'm not certain, Judge. I think it's over 500,000.
Okay. And you have the ability to liquidate some of those assets at this time?
Yes, sir.
Okay. Ms. Levinson, do you have a job at this point in time?
I don't.
Do you have any other source of income?
I have investments as well.
And what are your investments worth?
About 200,000.
Do you have the ability to liquidate any of that at this time?
I mean, it's inherited, so I'll take a big tax cut on it if I need to, but it's pretty brutal.
All right. Well, are either of you receiving any type of governmental assistance at this time?
No, sir.
All right. Well, I understand the tax concerns, but neither one of you qualify as indigent for the court to continue indigent services in this case. So I'm going to allow the attorneys to remain on the case long enough to get this order entered. But you're both going to need to look for attorneys because you have the assets to pay for one. Or it's not going to pay for attorneys or order the county to pay for attorneys when you have assets of that value. And what I'm going to order, Mr. Levinson, you two are married?
Yes, sir. We're
All
separated.
right. Mr. Levinson, I'm sorry, Ms. Swallow.
Their divorce is pending, Judge.
Okay. Without getting too much into the divorce, because that's not my jurisdiction, the assets that you have, Mr. Levinson, when you talk about $500,000, stuff that you can liquidate, is that community property?
Not necessarily.
Is any of it community property?
I think yes.
All right. Then what I'm going to order is that you two, again, Ms. Swallow and Ms. Acosta are only bound to get this order entered, and then their services are dismissed. I'm going to order that the two of you look for attorneys, and if you want one to represent you, you're entitled to an attorney. You don't have to have one, but I can't keep an indigent finding in this case to allow Ms. Swallow and Ms. Acosta to remain on case because you don't meet the qualifications of an indigent person. So what I'm going to order is that you, Mr. Levinson, through any community property funds that may exist, try to secure an attorney, not only for yourself, but for Ms. Levinson. Now, obviously, you're separated, so you're going to need two different attorneys. You can't have the same attorney. That's not going to work. That's a conflict of interest. If that doesn't work, if you two can't figure it out, then Ms. Levinson, you're going to have to, whatever assets are in your name, you're going to have to use to hire an attorney. Okay? I'm trying to do this in the most economic way possible, but I can't go out of my jurisdiction and make an order that is only proper under the jurisdiction for the court handling the divorce. Which court is it? Is it?
It's the 451st, Judge.
The county?
Your Honor, I'm happy to do that.
Okay, well, I understand that, and that's why, I mean, I can't specifically make that order. I just wanted, hopefully, the two of you could figure that out.
Absolutely.
And then we'll hold an indigency hearing at every hearing. And if either one of your circumstances change, then we could take this up again, decide whether or not Ms. Swallow or Ms. Acosta needs to come back. The last thing I want you to do is be in a situation where you don't have an attorney, but I can't find you indigent. You don't meet the qualifications. I would be making a decision going against the face of the law, and I can't do that.
Well, I understand.
Is there anything else besides the admonishment that I have not addressed?
Judge, I believe that placement is trying to secure and get copies of the necessary documents for the kids, social security cards, birth certificates, shot records, those sorts of things for enrollment in school, daycare, all of that sort of stuff. So we just asked that the parents provide those documents to the department so we can provide them to placement and or be ordered to do so.
All right, Ms. Saxon, are you the placement? She's muted.
Sir, yes, sir, I am.
Okay, and you're having a hard time getting this information?
I have the shot records, I think, all now, but I don't have birth certificates or socials.
All right, who has those, Ms. Levinson or Mr. Levinson? Which one of you has that information?
I believe I have one, and there's one at the RAN, but I've provided them with the pediatrician's name and number so that they can verify everything.
All right, I'm going to order the parents to provide that information. Whoever has it, you need to provide that information to Ms. Saxon within the next 5 days.
Okay.
Sure.
She needs that in order to help take care of the children. All right. And I am, because it's part of the agreement, ordering Mr. Levinson to enter inpatient, and that needs to be as soon as there's a bed available. Ms. Mance, is there anything else that you want to add?
Judge, is child support deferred to the 60-day?
Yes.
All right, I just didn't know if I missed that. Thank you.
I want to, there's a lot that needs to be done right up here at the front, and I want these parents to be able to get started on services and get things figured out. So we'll defer that to the status hearing. The status hearing is going to be February 22nd, 2023 at 10:30. February 22nd, 2023 at 10:30. Appreciate you all being able to come to an agreement. And I think that'll get everybody off on a good start in this case. And I have to admonish both the parents that the state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your children. If you cannot do that within 12 months, your rights to your children are subject to restriction, as they are now, or termination. All right, that'll be the order of the court. Thank you all for your time and your service. If nothing further, all parties are excused. Mr. Levinson and Ms. Levinson, good luck.